Hello, this is Fariha Rifath Juthy and this is my student ID. So today I'll talk about three of the most important rules which govern sea law. One is Hughes-Bisbee rule, and then there is Hamburg rule, and then there is Rotterdam rule. Mostly I'll talk about the carrier's duties and immunities under this rule. Firstly, there is the Hughes-Bisbee rule. It is an amendment and modernization of the original Hughes rule. Primarily, it focuses on the carriage of goods by sea. They represent a significant step in standardizing international maritime law, particularly concerning the carrier's responsibilities. The key duties under this rule is the carrier is tasked with ensuring the ship's seaworthiness, which involves through inspection and maintenance of the vessel to make it fit for the journey. This duty extends to properly loading, handling, stowing, and carrying the cargo throughout the journey, ensuring its safety and integrity. The additional responsibilities under this rule is the carrier under this rule also ensure that the ship is adequately manned, equipped, and supplied. This comprehensive approach to the vessel readiness and crew competence is important for the safe and efficient conduct of the voyage. Then there is Hamburg rule. This rule was introduced later. It aims to enhance the protection afforded to the shippers by imposing more obligation on the carriers than the previous Hughes-Bisbee rule. Then there is like expanded carrier's obligation, which is from the moment the carrier takes charge of the good, they are responsible for their care, extending this duty until the delivery is complete. The continuous chain of responsibility marks a shift from more limited scope under the Hughes-Bisbee rule. Then there is enhanced focus on the seaworthiness. This rule emphasizes the maintenance of the ship's seaworthiness not just at the outset but throughout the journey. This ongoing responsibility underscores a heightened, more standard of care expecting from the carrier. Then there is Rotterdam rule. It represents a more contemporary approach to the maritime law. Though their adoption is not as widespread, this rule acknowledges the evolving nature of international trade and shipping practices. The extended responsibilities under this rule is they broaden the carrier's duties beyond traditional loading and discharge phases, reflecting the complexity of modern shipping like containerization and digitalization. Recognition of modern practices. The accommodation of electronic transport record and the acknowledgement of multi-modal transport are significant inclusion that align with the current industrial practices. The immunities of carriers under these rules are the Hughes-Bisbee rule. There is limited liability. So this rule offers carriers several immunities, like key among them being the exemption from the liability for the loss or damage arising from seaworthiness, providing due diligence was exercised. There is specific exemption. Carriers are also immune from liabilities arising from the act of God, war, public enemies, and inherent defects in the goods, and acknowledging the uncontrollable external factors. Then there is Hamburg rule. there is reduced immunities. In contrast to the Hamburg rule, significantly limit the immunities available to the carriers, tilting the balance towards shippers' protection. Due diligence requirement. Carriers can claim immunity only if they demonstrate that all necessary steps to prevent the loss and damage were taken. As stipulated, that places a heavier burden of proof on them. Then there is Rotterdam rule. It is a balanced framework. There is balance framework. This rule strives to strike a balance between the duties and immunities of carriers, reflecting the modern shipping practices. And there is extended liability period and volume contracts. They extend the period of carrier liability and introduce volume contracts which allow negotiation in terms including liabilities and immunities within certain mandatory standards. There is challenge and proposed reforms in maritime law. The challenge is the critical comparison of Hugh-Bisbee, Hamburg, and Rotterdam rule reveals several challenges in current international maritime law framework. Inconsistent global adoption. One of the primary challenges is the varied adoption and application of this rule across different countries. This results in lack of uniformity in maritime law globally, leading to complexity in international shipping and legal disputes. So, conflicting interests of carriers and shippers. These rules differ in extent to which they protect the interest of carriers versus shippers. While the Hugh-Bisbee rule are seen as more carrier-centric, the Hamburg and Rotterdam rules shift towards offering greater protection to the shippers. This often leads to the tug of contractual agreements and disputes resolution. Adoption of the modern shipping needs. Another challenge is the adaptation of these rules to contemporary shipping practices. The rise of digital documentation, electronic tracking, and multimodal transport necessitates an update to the existing legal framework to address these new realities. The proposed reforms are in response to these challenges. Several reforms have been proposed within the maritime legal communities, like development of a unified legal framework. There is a growing need for the harmonization of set of rules, such as framework could aim to integrate the best aspects of the Hugh-Bisbee rule, Hamburg and Rotterdam rule, while also incorporating a modern shipping practices. This unified approach could reduce legal uncertainties and provide more predictable legal environment for the international shipping. Enhance flexibility and adaptation. Modern maritime law, it needs to be more flexible. So it needs to be that much flexible to the technical advancement and challenging global trade pattern. Proposed includes the incorporation of provision for electronic documentation and recognition of digital signature, along with the laws accommodating the increased prevalence of multimodal transportation. So there is balancing carriers and shippers' interest. Reform should also aim to establish fair balance between the rights and responsibilities of the carriers and shippers. This could involve redefining liabilities clauses, standardizing the burden of proof requirement, and introducing more equitable risk-sharing mechanism. There is global ratification and enforcement. So effort should be made to encourage wider ratification and uniform enforcement of the reformed rules. These would involve diplomatic efforts, international collaboration, and possibly incentives for countries to adopt and rigorously enforce these unified rules. So there is research question. The question is, how do the career's duties and immunities differ and intersect across the Higgsby, Hamburg, and Rotterdam rule? This question seeks to dive into the set of rules, examining not only the differences but also common aspect of the duties and immunities prescribed for careers, thereby providing a comprehensive understanding of international maritime law. Second question is, what are the legal and practical implications of jurisdictional variation in the adoption and applicability of these maritime rules? This inquiry aims to explore the real world impact on how different countries interpret and implement the Higgsby, Hamburg, and Rotterdam rule. The focusing on the challenges of this poses for international shipping operation and legal dispute resolution. Third question is, in what way can harmonization of international maritime law be achieved, and what would be the potential impact on global maritime law? So this question investigates the potential pathway towards harmonizing these rules globally, analyzing proposed reforms for their feasibility, and evaluating the prospective effects such as harmonization such as on international maritime industry. There is research method. The chosen research method are well justified given the complexity and international scope of the topic. It focuses comparatively legal analysis is the backbone of this research, providing a structured approach to dissect and compare the significance of the maritime rules. This method is particularly adapted for identifying the nuanced differences and similarities that have significant implications for international maritime law and practice. So lastly, the targeted literature review serves to anchor the legal analysis within existing academic discourse, ensuring that the research is uniformed by and contributes to the scholarly debate on the subject. Focusing on literature that examines the comparative dimension of these rules provides a thorough understanding of the broader context in which this legal framework operates. Together, this method will afford a comprehensive exploration of the career's duties and immunities under the three sets of rules, ensuring research is grounded in both theory and practice. Thank you.